chapter is civil rights. So, last chapter was civil liberties, and we talked about how civil liberties pertain to the protections that we get through the Bill of Rights. Now, civil rights are different. Civil rights have to do with discriminatory behavior based on things like race, sexual orientation, gender identity, all of those kind of things. So, civil rights has been addressed in a lot of different ways through acts passed by Congress, um, through amendments as well outside the Bill of Rights. So, this chapter, we're going to kind of look at the struggle for civil rights for several different groups in our country and look at some of the court cases and bills passed by Congress that help kind of ensure those civil rights. So, civil rights have to do with discrimination. And when we talk about discrimination, we mean unreasonable and unjust criterion for exclusion. So, anything that prevents people from being able to access equal opportunities in this country, such as education, jobs, anything like that. So, civil rights are government protected rights against arbitrary and discriminatory treatment by government or individuals based on categories such as race, sex, national origin, age, religion, or sexual orientation. Now, gender identity is not included in civil rights just yet. Most of the other categories that we just listed there have had Supreme Court cases and bills passed in Congress relating to those issues. Gender identity is not one of these areas that is protected just yet. Now, I foresee in the near future that we will probably have court cases on the issue of transgender identity and adding those protections to civil rights, but as of right now they are not currently included. Much of civil rights legislation depends on the 14th Amendment. And we refer to the 14th Amendment, the part of the 14th Amendment as the Equal Protection Clause, that any person within the jurisdiction of the United States is entitled to equal protection of the laws. And so this addresses having different laws in different places. And we know throughout the struggle for civil rights, the South used things like segregation and basically creating a two-tiered society to claim that, society was separate but equal, and we'll get into that more in a minute. But after the Civil War, many of the states, especially the southern states, tried to make the argument that these protections, civil liberties, civil rights, didn't apply because they were federal rules and that the states did not have to enforce them within their jurisdictions. And so the 14th Amendment is passed in a succession of 3 amendments that have to do with civil rights, and it kind of shuts the door for the state creating their own discriminatory laws. So, going back to the period right after the Civil War, those amendments that are passed are the 13th, the 14th, and the 15th. The 13th Amendment banned all forms of slavery and involuntary servitude except one. So 13th Amendment essentially abolishes slavery among free persons, people who are living in our country. The exception to the 13th Amendment are people who are incarcerated. Incarcerated people can be forced to work for no pay or less than minimum wage, which still happens in our country today. So if people say, people tend to say, oh, slavery's been abolished in the United States. Technically, that's not a correct statement because we still have unpaid labor or underpaid labor in our prison system. Now, after the 13th Amendment is passed, the southern states respond with what are called the Black Codes. And there's a link here on this page to a video from the History Channel about what the Black Codes are. But essentially, they are the first attempt by the southern states to maintain the way of life they had become accustomed to. So the Black Codes prevented newly freed African Americans from voting, sitting on juries, being in public spaces where they were not wanted. If a black person offended a white person in Southern society, that person still, even after the abolishing of slavery, could beat them in the street, and those actions were protected. So the Black Codes were kind of the predecessor to Jim Crow, which we'll talk about in just a minute. But essentially setting up this idea that African Americans belonged to one segment of society and that white citizens were the top tier of society, and that's what the Black Codes were meant to do. Um, our first Civil Rights Act is passed in 1866, and this act is passed to essentially eliminate the Black Codes. Um, Congress passes it. President Andrew Johnson vetoes it. He is not a fan of the abolition of slavery or getting rid of this way of life. And so Congress overrides his veto. And essentially, the Civil Rights Act declares all African Americans citizens and gives the court the authority to protect their rights. Andrew Johnson actually faces impeachment because during the Reconstruction era, he was siding with the South over the rules that were being imposed by the Union. Um, Voting was a big part of this at the time because African Americans, there were a lot of ways that African Americans were excluded from voting after they were freed from slavery. Things such as the poll tax, the grandfather clause, the literacy test, things like that. And so this essentially says that African Americans are citizens, and then we get the 15th Amendment shortly thereafter, guarantees all citizens the right to vote regardless of race, color, or previous condition of servitude. So this is an attempt to get rid of all of those means that the South was using to prevent African Americans from participating in society. Now, shortly after these amendments, we get the Civil Rights Act of 1875. This grants equal access to public accommodations such as restaurants, theaters, transportation, schools, all of that kind of stuff. And so the South essentially interprets this how they want to interpret it. And this is what establishes Jim Crow law in the South. The name comes from a popular minstrel character at the time. It was a white person in blackface, and the character was named Jim Crow. And we've all seen depictions of this, so you probably know what I'm talking about. But essentially, what these laws do is they say that as long as the southern states are providing accommodations to African Americans, that African Americans and whites do not have to occupy the same space. So they provide schools, restaurants, railroads, theaters, things like that, that are for whites only and that are for African Americans. And so they feel that this satisfies the idea of equal access. They interpret it as equal access but not shared access. And they also institute a ban on interracial marriage at this time as well. So the first challenge to Jim Crow comes in 1896, the case Plessy versus Ferguson. If you've studied civil rights at all, you probably have heard of this case. A gentleman from Louisiana sues over the issue of segregation. If you know much about the culture of Louisiana during this period of time, there were lots of interracial people in Louisiana because many of the wealthy white slave owners would have black mistresses and have offspring, would have children who were very light skinned. And so this gentleman in the case basically looks white, but we have this rule during this time period called the one drop rule. Your ethnicity, if you have one drop of African blood or one drop of Native American blood, whatever it is, you are considered that race, regardless of what you look like. And so, in this case, this gentleman believed that he should not be segregated because he looked white. And essentially, the Supreme Court rules that separate accommodations are equal and allowable under the law. So Plessy versus Ferguson upholds the idea of Jim Crow law for quite a while. Um, we talked about the ways that African Americans were prevented from voting. Poll taxes were essentially fees that someone had to pay to exercise their right to vote. At this time, many African Americans did not have the best jobs. A lot of them ended up working on the same farms that they had been slaves on and getting paid very little. And so you had to make a choice between paying a poll tax to vote or having enough money to feed your family or pay your rent or whatever it is. And so this kept many people from voting. Literacy tests were also used because most slave owners did not educate their slaves. So upon receiving their freedom, you have this entire class of people who do not know how to read, do basic math, any of this kind of stuff. And so before you were allowed to vote, you had to pass this exam. And essentially, it would not only test whether you knew how to read, but it would have questions about, the Constitution and American government and things like that on it. Things that most African Americans at the time had no clue about because they had never been educated. So this was, two of the most popular ways that African Americans were prevented from voting. And this is what Jim Crow looked like. So you would, in most southern places, you would see these signs like this that would say, that you can't come in here, or that you would be served in a separate part of the restaurant, or separate restrooms, drinking fountains. And it wasn't just applied to African Americans. We can see here Mexicans, Japanese Americans. This is closer to World War II, when we go to war with Japan. Essentially, we're seen no better than dogs, and we're essentially forced into a secondary society. And even though these accommodations were, quote unquote equal, they, the schools for people of color were not as good as the schools for whites. The people of color had to give up their seats on the bus to white people when it was demanded and things like that. So this was essentially a system to subjugate people of color and, keep them in their place, so to speak. Now, um, once we get into the 1900s, we start to see movement among people of color to start fighting for the advancement of civil rights and equality. And of course, the most well known group is the NAACP, the National Association for the Advancement of Colored People. Obviously, we don't use that terminology anymore, but the organization was created in 1909, and I'm sure they don't want to change their name because it's so historic. But the NAACP, under the leadership of W.E.B. Du Bois, start organizing the African American community, pushing for equality, voting rights, ending segregation, and the rights of women and children. And the NAACP has been a party to some of the most important Supreme Court cases in American history. And they're responsible for really pushing the civil rights movement, whether it was through financing, whether it was through representing people in court with attorneys, whatever it was. They've been there at every step of the civil rights struggle of African Americans and allied with other groups in their push for civil rights as well. In the 1930s, the NAACP starts to use the court system to challenge the constitutionality of the idea of Jim Crow laws. And this also leads to the creation of the system of historically black colleges and universities we have today. Many universities were segregated and did not allow African Americans to attend. So many of the leaders, associated with the NAACP, start establishing colleges for Black Americans to get their education. Many of them will become attorneys and come back and work for the NAACP to start fighting for civil rights in the court system. Um, this is one of the smartest things that they do is realize that many of the amendments in the civil rights acts that were passed in the 1800s open the door to use the court system to create change. And so they start organizing using the numbers of people they have fighting for this cause, exercising the right to vote to create change in the election system. And then, of course, Brown versus the Board of Education is considered the most important case in American history in the 20th century. So Brown versus Board of Education, most of you have heard of it, but kind of the circumstances that lead up to this. This is post World War II, so this is 1954. And many men are returning to the country after fighting in World War II. And when they're coming back to the United States, white men are being given a lot of opportunities. They're being given low interest loans to buy homes. They're given funding to go to college and get their education. And this is where we really see the creation of the middle class in America because of all these benefits that are being given to the veterans of World War II to improve their lives when they get home. Except African Americans, Latinos, Native Americans, and Asians, that fought in the war on behalf of the United States are excluded from these benefits. And so, especially among African Americans, they go to Europe and they go abroad and they see that they're not treated the same way in other countries as they're treated in the United States. And then they come home and they're being denied all of these opportunities. And so, things really start with Brown versus Board of Education. There's some rulings leading up to this, but in the case Brown versus Board of Education, the NAACP essentially is making the argument that the 14th Amendment made segregation unconstitutional. And the only way to equalize society is to integrate society, not just schools, which is what the case was based on, but fully integrate society. There's different levels of scrutiny that the courts will apply to certain cases. The highest level of scrutiny was applied in this case, which meant that the states, the responsibility was on the states to convince the court that segregation was necessary. So the NAACP presented a very strong case, but the states really had to convince the Supreme Court that there was a reason and a need for segregation. Much of the argument that the NAACP makes is that segregation is having social and psychological effects on the African American community, that essentially classifying an entire group of people as inferior or second class citizens is hampering their ability to be successful. This is a very strong and compelling argument. And in this case, the court strikes down Jim Crow law and segregation in the South. And like we said, it becomes known as the most important case in the 20th century. And of course, as people are wont to do, many of the politicians of the day, the Southern politicians, say that ending segregation will be the end of civilized society and the country is going to fall apart and descend into violence. Well, it does, but most of the violence is enacted by white Southerners, not African Americans. But this does not settle the issue of civil rights. It will be another decade before we get some concrete bills that come out of Congress. Um, but what it does get rid of is de jure segregation, which is segregation by law. But what we still have in our country today is de facto segregation, which means that as people, we still tend to kind of segregate ourselves. You can drive around any major city, and I live in Fort Worth, so in Fort Worth, Stop Six is historically African American, North Side is historically Latino, and so we as people still tend to kind of segregate ourselves, even though it's not ordered by law anymore. And there's a lot of reasons for that. People tend to feel comfortable around people that look like them. They feel more welcome and things like that. But, you know, ideally for us to keep progressing as a country, all of this, living together, working together, all of that is good for us because it helps us see each other more as Americans rather than a black American or a brown American or a white American, stuff like that. Granted, we don't segregate ourselves in the way that we do business and stuff like that, really, but where we choose to live is still heavily segregated. And that's something that maybe you could write about for your discussion post, like why that is. All right. Now, some important moments in the African American struggle for civil rights. 10 years after the Supreme Court's decision in Brown versus Board of Education, only 1% of schools in the South had been integrated. And this points out, this really highlights one of the biggest issues with the court, is that the Supreme Court is the highest court in the land, and their decisions create law in our country. The problem is that the court has no mechanism to enforce these decisions. They leave that up. That has to take place in the legislative branch and the executive branch. And really, both of them didn't do a whole lot to end segregation, even after Brown versus Board of Education. And the southern states weren't going to comply. They're the southern states. And so in 1955, the Supreme Court rules that, again, in a case known as Brown versus Board of Education 2, that this needs to happen, that the school system needs to be dismantled and integrated. And then we get another case in 1958, Cooper versus Aaron, where the southern states request another 2 years to do this, and the court refuses and says, you've had several years now to do this. We're not going to delay this any longer. But we know that the civil rights movement continues because this is still happening in the South. There's no enforcement of these decisions. And then we get some of the things that we're very familiar with. December 1st, 1955, Rosa Parks makes history by refusing to give up her seat and move to the back of the bus to accommodate a white citizen in Montgomery, Alabama. This was part of Jim Crow, that if you were a person of color and a white person wanted your seat in the front of the bus, you had to get up and move to the back. Rosa Parks makes history by refusing to do this, and she is arrested. And in response to this, in Alabama, African Americans organize a boycott of the public transportation system, and it actually has very significant economic effects. African Americans are using public transportation at much higher rates than white citizens, and depend on it from getting from place to place. But once they decide to boycott it, it has enough of a financial impact that the public transportation system almost goes bankrupt. And so they eventually cave in because of the financial pressure of the boycott and change the rules, having to do with where people sit. In 1956, the federal court rules that segregated transportation is a violation of the 14th Amendment and it has to stop. 1957, a young man named Martin Luther King Jr. forms the Southern Christian Leadership Conference as a way to organize African Americans and use black culture, religion, and nonviolence to oppose segregation. And we'll we'll talk more about that in a moment. Some other things that are happening. February 1st, 1960, black students from the North Carolina Agricultural and Technical College in Greensboro stage a sit-in protest at a diner. If you look this event up, there are a lot of pictures of it. Essentially, what they do is they just go into a diner and sit down at the counter, violating these ideas of segregated dining spaces, and they just sit down at the counter and try and order coffee and food, and they are refused service. People start to crowd around them and start yelling at them and punching them and dragging them out of the diner, and they are arrested. Um, Later that same year, the Freedom Rides began. The Freedom Rides were essentially a group of black and white college students who essentially they just rent buses and ride around the South on buses together to show that there's no reason for segregation, that black and white students can get along. There's nothing to worry about. There's nothing to fear. But these freedom rides are, the public does not approve of them. In some places, they are assaulted, and in one instance, some of the freedom riders are actually killed in Mississippi. So the opposition to this idea of integration is very intense. Um, and then MLK, by 1963, launches a series of nonviolent protests. And so many of you may have read some of Martin Luther King's like letter from a Birmingham jail, and of course the "I Have a Dream" speech and things like that. Um, Martin Luther King believes in nonviolence, and he believes that uh, it will just oppose African Americans against the violence that they are enduring, and when people see those images, it will make them sympathetic to the cause of civil rights. And so they essentially start training their protesters to not react violently when they are beaten, sprayed with water hoses, attacked by dogs, and things like that. And this is what that looks like. And so these images are going out not just to the United States, but to the rest of the world. And so at this time, the United States is now viewed as kind of like the leader of the free world post World War II. And we're telling other countries what they should and should not be doing, but yet we're doing this to citizens back home. And so it kind of undermines our credibility and our place in the world. And people in the North, that don't see these protests on a daily basis, finally start to see images of what this looks like, and it starts to kind of change public opinion on the issue of how African Americans are being treated. Now, we know that Martin Luther King was just one perspective at this time. There were others um, like Marcus Garvey and Malcolm X and the Black Panthers a little bit later, who did not share Martin Luther King Jr.'s sentiment of nonviolence. Malcolm X spoke very plainly about the need for gun ownership and things like that to protect for Black Americans to protect themselves. So there was not a consensus about which method was, I guess, the best course of action. But Martin Luther King's movement did create a response from government. So in 1964 and 1965, we get two of the biggest pieces of legislation from that have to do with civil rights. We get the Civil Rights Act of 1964 and the Voting Rights Act of 1965. When JFK runs for office in 1960, he talks about civil rights and the need to do something about civil rights in our country, and he's very committed to creating some kind of change through legislation or whatever to deal with the issues that are going on in the South. Um, he he writes letters with Dr. King and meets with different leaders of the civil rights movement. Unfortunately, JFK will be assassinated in 1963 and does not live to see, the progress that is made through these two pieces of legislation. His vice president, LBJ Lyndon Johnson, comes into office after Kennedy's assassination and very quickly makes these two acts a priority of his administration. In some respects to honor JFK, and in some respects because he believed they were right. So the Civil Rights Act outlaws arbitrary discrimination in voting and allows for expedited lawsuits that have to do with voting rights. Bars discrimination in interstate commerce. Remember, we talked about that in federalism, where any business crossing state lines is under the authority of the federal government. Um, Authorized the Justice Department to initiate lawsuits to desegregate schools. So now the Justice Department and the executive branch are involved in forcibly making sure that schools are integrating. Withheld federal funds from discriminatory state and local programs. So remember, in federalism, we talked about how the states take grant money from the federal government, and most states rely on this money pretty heavily. In the state of Texas, federal grant money makes up 1/3 of our budget. So it is a very significant amount of money. And so now Lyndon Johnson authorizes the federal government to withhold grant money from the states if they do not comply with civil rights legislation. And this is probably the most important part of these two pieces of legislation, is that now there is a enforcement mechanism for the federal government to make the states comply with civil rights bills. Prohibited discrimination for employment and creates the Equal Employment Opportunity Commission, which still exists today. You can file complaints if you feel you're discriminated against and initiate lawsuits against your employer. So these are the two big ones, but of course we know that civil rights is not a settled issue. We are still debating and arguing over civil rights today. But this kind of lays the groundwork for legal enforcement of civil rights issues. And so some of the areas that we're dealing with also are addressed in court cases as well. We talked about the levels of scrutiny. The three big areas that still have to be dealt with are voting, which the two acts address. Housing is still one that many people argue we're dealing with today. Back prior to the Civil Rights Act and the Voting Rights Act, there was a practice known as redlining. And essentially, banks are the ones who give the loans for people to buy homes. And so you have all these people coming back from the war, getting loans to buy a home. And this is where we see the development of the suburbs, because white citizens are fleeing the inner city and moving out to these new communities outside the city to get away from integration, essentially. And it's called white flight. And the banks engage in this practice known as redlining, where certain areas of the map would be outlined in red, and they would not loan money to people to buy homes in those areas, nor would they loan money to people who lived in those areas to buy a home somewhere else. And so essentially what it did is it kept people of color trapped in low income neighborhoods with not as nice amenities, lower performing school districts, maybe more crime and violence and things like that. And a lot of people believe this led to the creation of the modern idea of the ghetto that we have, that essentially people of color were prevented from moving out of these areas. And then we see a lot of the social effects of staying there, whether it's lack of education, lack of opportunity, whatever it is. And then, of course, in 1976, we have the Loving case, which gets rid of the ban on interracial marriage. A lot of civil rights cases use that level of strict scrutiny where the state has to prove why they need to discriminate. And very rarely will a case hold up to strict scrutiny. First and second level scrutiny are the requirements are either at the first level, the requirement is on the plaintiff to prove that they have been discriminated against. We usually see this in, lawsuits and stuff like that. Second level, intermediate scrutiny. This is used in gender cases like sexual harassment, where both sides have to provide evidence to prove their arguments, things like that. Another policy that goes into effect, affirmative action. Affirmative action it's pretty misunderstood today. Most places do not use affirmative action any longer, especially colleges and universities. Most public institutions do not rely on affirmative action. It's still permissible and allowable. It's just that it's not really needed anymore because most colleges and universities have become very diverse on their own. But essentially, affirmative action were different policies and programs to promote integration in the workplace by, giving, rewards for making an effort to hire people of color, to admit them to the universities and schools and things like that. But again, it's diversity in a lot of places has kind of addressed itself, and we see a lot of diversity in the workplace and in public universities and stuff like that. Where we still are, having issues is, private colleges like your Ivy League colleges, stuff like that, high level corporate jobs, the tech sector, places like that. So some of those places may still use affirmative action to a limited degree, but for the most part, most businesses and universities are not using affirmative action in the way that it was used before. All right, now women's rights and the struggle for the right to vote. So, prior to the Civil War, there had been a push for women getting the right to vote. Now, of course, this was white women, not women of color. But the struggle for women's suffrage or the right to vote starts prior to the Civil War. But of course, once the country gets engulfed in the Civil War, it kind of takes precedence over everything else, and women's suffrage gets kind of pushed to the side. But once the war is over, closer to the turn of the 20th century, 1890, we see the creation of the National American Woman Suffrage Association, which is headed by Susan B. Anthony. Most people are familiar with Susan B. Anthony. She's been on coins and all that kind of stuff, and is kind of recognized as the mother of women's suffrage. But in addition to the right to vote, the NAWSA pushes for things like temperance laws, minimum wage for women, improved sanitation conditions, public morality, and education. So, temperance laws, if you're not familiar, is laws having to do with alcohol consumption, which we will eventually get prohibition. That is not successful. But there are a lot of things that the women's movement is responsible for that we often don't acknowledge. One of the earliest cases that comes out of the women's movement is Muller versus Oregon in 1908. A Supreme Court case brought by the National Consumers League on behalf of women in Oregon to limit the workday to 8 hours. To 10 hours. Prior to this case, if you were an employee, you had to work whatever hours your employer needed you to work. And if you didn't want to, then they would just let you go and hire somebody who did. And women made the argument that, without having any kind of restriction on the length of the workday, it took parents out of the home, that children were being neglected, that it led to immorality and drunkenness and all this kind of stuff because people were, just dealing with the harsh conditions that this created, and that the workday needed to be limited to kind of keep the family unit together. And the Supreme Court agrees, and so we get this ruling to limit the workday to 10 hours. Now, eventually, that will be shortened to 8 hours, which is what we have today. Um, one of the biggest criticisms of the women's movement at this time is that it is not inclusive. It is solely pushing for the voting rights of white women. Um, Susan B. Anthony, in today's light, is criticized for some of the things that she said. One of her ideas about women voting is that uh, she is quoted as saying, if undereducated African American men and immigrants could vote, why not white women? So it does show a bit of this idea of superiority of white women over people of color. Um, so it's not inclusive, and even women's movements today are still dealing with the issues of intersectionality and whose issues that the causes they're taking up. But in 1920, we get the 19th Amendment, which grants all women the right to vote. 2 million women and President Woodrow Wilson support the passage of the 19th Amendment. After the 19th Amendment is passed, the women's movement kind of falls apart because they don't have this single thing that holds them together that they're all advocating for. And so we don't see the women's movement kind of reemerge until the 1960s during the civil rights struggle. Um, in the 1970s, we get a amendment proposed called the Equal Rights Amendment. And essentially what this amendment would do is prohibit discrimination on the basis of sex, whether it was for employment, opportunity, education, whatever it is. And the states refused to ratify this amendment. And a big reason why is Roe versus Wade. The Equal Rights Amendment would have guaranteed women access to abortion in 1972. And this is while the courts are still dealing with the issue of abortion, and we get Roe versus Wade in 1973. So the states essentially refused to pass the Equal Rights Amendment because it would have legalized abortion. And so it's essentially just kind of voted against and forgotten, but there's been talk of a new Equal Rights Amendment today. We get the Roe versus Wade decision in 1973. Also in the 70s, we get Title IX in educational institutions. Title IX basically states that any education institution that receives federal money cannot discriminate against women and has to provide equal opportunities. So, like at our university, if you're going to give men a scholarship to play a sport, there has to be those opportunities for women as well. Title IX creates a mechanism for dealing with sexual harassment, all that kind of stuff. Equal Pay Act of 1963 requires employers to pay men and women equal pay for equal work. Today, it is believed that women still only make 75 to 80% of what men make in the workforce. Now, this is one of those things that makes people uncomfortable to talk about. There are genuine instances of gender discrimination in pay that do exist. They're documented. There have been court cases over them, like the one we're going to talk about in a second. But there's another reason for the discrepancy in pay between men and women. And some of it just comes down to the careers that people choose to do. Men heavily dominate tech, engineering, science, constitute most of business CEOs. These are the fields that we pay the most. Women, statistically, this isn't, a broad generalization, but statistically, women tend to be more drawn to careers that have to do with nurturing and caring type things. Like we have more women teachers in our country than anything else. We have more women in the medical profession as nurses and doctors and things like that. We have more women in social work and psychology. These are fields that take care of people. Unfortunately, we don't value those things the way they should be valued, and so those professions tend to make less over the course of an entire career than the tech field, engineering, things like that. So that also contributes to this inequality in pay. What the Equal Pay Act is addressing is that when men and women do the exact same job, they should be paid the exact same wage. Um, so if a woman goes into tech, there's no reason why she should be paid less than a man in the tech field. So that's what the Equal Pay Act is addressing. In 2007, President Obama passes a piece of legislation called the Lilly Ledbetter Fair Pay Act. Um, there was a court case in 2007. Lilly Ledbetter had worked for the Goodyear Tire Company for her entire career. She found out after she had retired that over the course of her career, she made 40% less than her male counterparts. So she sues, and the Supreme Court sides with the employer because the regulations state that a case must be filed 180 days after discrimination occurs, within 180 days. And because she doesn't file this case until after she is retired, the court says they can't do anything because of the regulations. So in 2009, President Obama signs the Lilly Ledbetter Fair Pay Act, which overturns that Supreme Court decision and essentially allows a person to sue their employer for discrimination that occurred over a long period of time when they become aware of that discrimination. So now she can go back and sue the Goodyear Tire Company for everything she is owed over the course of her entire career. So Lilly Ledbetter Fair Pay Act is still in effect today and is a strong encourager for employers to make sure they are paying people fairly. Title VII deals with sexual harassment. Title VII of the 1964 Civil Rights Act allows for cases regarding sexual harassment and recognizes two types of sexual harassment. One is quid pro quo. This is the most common, which is quid pro quo essentially means this for that. So you do this for me, I'll do that for you. So essentially implying that you'll get a job or a promotion in exchange for sexual favors. That's quid pro quo sexual harassment. And then hostile environment creates an offensive or intimidating work environment once someone either turns down someone's proposition or reports it or something like that. Title VII is what handles this with employers. Title IX addresses it on college campuses. So on college campuses, there are protections against sexual harassment that go beyond, the workplace as well. Latino civil rights. Now, the rest of the groups that we'll talk about are groups that you don't really hear about when you're taking your high school courses about history and government and things like that. Every group, every minority group in this country has had their own struggles when it comes to civil rights, and we are still seeing those struggles today. And so with Latinos, Latinos have been present in the United States longer than white people. The Spanish, if you're unfamiliar, Latinos are people of Spanish and indigenous heritage. So you are typically some part Spanish and some part Native American or indigenous people in Central and South America. Latinos have been present in the United States since about 1520 or so, 1515, somewhere around there. The first white settlers don't get here until the 1600s, so Latinos have actually been here longer. Many Latinos, though, immigrate to the United States early in the 20th century because there's a lot of instability in Central and South America, much of it the fault of the United States. And so because of the violent uprisings in Latin America, many people flee to the United States. Many Latinos volunteer to fight in World War I and World War II. And back then, you could get citizenship through fighting for the military. Today, it's not guaranteed anymore. It's still a possibility, but it's not guaranteed. But even though they volunteer and fight in the world wars, they come home and face the same discrimination as African Americans. And so they kind of follow the same playbook and create their own organization. The League of United Latin American Citizens, or LULAC, is formed in 1929. And again, it is using the court systems to fight for equal treatment under the law and recognition of their civil rights. The GI Forum is created by LULAC to help Latino veterans get access to those benefits that they're being denied, such as home loans, education, having their education paid for, stuff like that. A couple of important court cases having to do with Latino civil rights. Hernandez versus Texas. um, Essentially prohibited discrimination against Latinos on the basis of race, in that Latinos have the right to have other Latinos on their jury during their trial. So, what was happening all across the country, and especially in the South, was when a person of color would go on trial, they would be tried by a jury of all white citizens. And in this case, it is argued that, the Constitution says that we have the right to a trial by a jury of our peers, and that a jury of our peers should reflect the communities that we live in. So there should be Latinos, African Americans, and everyone else on our juries. And that by excluding them, you're essentially making the justice system less fair. And so in this case, we established the idea that all people of all color have to be allowed to serve on juries. Mendez versus Westminster is actually a predecessor to Brown versus the Board of Education, and this precedent is used in those arguments that in California public schools, Latinos are being segregated from white students. And so in this case, it is ruled that California must allow Latinos to attend school with white citizens as well. And the precedent it sets is used in the Brown versus Board of Education case. One of the biggest issues that Latinos have had to fight for is fair pay in our country. In 1965, the United Farm Workers Union is created by Cesar Chavez, whose picture is in the background, and Dolores Huerta. And in our country, for a very long time, much of the farm work, at least since the 20th century, has been done by Latino field workers. And farmers were notorious for not paying these workers what they were due. Latino migrant farm workers are people who would travel around the country and follow the harvest season. So you might be here for one part of the year harvesting this type of crop and then travel north or west or east or whatever. So you're essentially following the harvest. And farmers were notorious for, they would have them do the job, and then when it came time to get paid, they would use violence to force them off the farm and drive them away or call the cops or whatever it was. And so Cesar Chavez organizes this movement to get fair treatment for Latino farm workers. And he uses many of the techniques that are used by Martin Luther King and the NAACP: boycotts, hunger strikes, protest, and nonviolence. And so this leads to the creation of a union for farm workers to ensure that they get fair treatment and fair pay. Unfortunately, one thing that does happen as a result is just, even today, a lot of farms will use undocumented farm workers so that they can not pay them what they should be paid and abuse them and do whatever they want to do, because those individuals will work for whatever. And so it undermines this idea of fairness. Also, the United Farm Workers Union leads to greater Latino participation in elections and the legal system. So, the Latino movement and the African American movement have kind of moved hand in hand. They typically have a lot of the same goals that they are fighting for. We're seeing even today a lot of support from Latinos for Black Lives Matter, and we have our own issues as a Latino community, such as DACA, immigration, the detention centers that are weighing heavily on Latinos as well, and will definitely influence how the Latino community votes in upcoming elections. Asian American civil rights is an area of civil rights we don't talk about too much, at least outside of Japanese detention. Um, Asians have been present in the United States since the beginning of the 1800s. But the United States government did not recognize Asians or Pacific Islanders as their own distinct ethnic group until 1977. Until 1977, they were classified as white. Latinos have had the same issue as well. When you fill out a document, Latino is not considered a race, it is considered an ethnicity. So you're forced to pick a race and then designate that you are Latino, which can skew the idea of how many people of a certain ethnicity and race are in our country. So you can imagine what that looked like up until 1977 when Asians were classified as white. It made the white population look larger than it was. But Chinese immigrants were the first immigrants to come to the United States. They came here just like everybody else for opportunity, and they became a source of cheap labor for building the railroads. But as more and more Asians start coming to the United States, many states start passing discriminatory laws against Asians. The Chinese Exclusion Act actually prevents people of Asian descent from being eligible for citizenship. It limited the amount of Asians that could come into the country, established that they could not be granted citizenship regardless of how long they had been here, and then denied the integration of Asian children into public schools. United States versus Wong Kim Ark, 1898, ruled that U.S.-born Asians could not be denied citizenship. So prior to 1898, even if you were Asian and born in the United States, you were not granted citizenship. They were essentially a second or third class of citizens who were denied citizenship, even though they were born in this country. And so that the Chinese Exclusion Act goes into effect, I believe, in the early 1800s, and is not struck down until 1898. So it is in place for a very long time. Yik Wo versus Hopkins, 1886, limited the professions that Asians could practice in the United States. There's always been this stereotype in the country about dry cleaners and certain restaurants and stuff like that always being owned and operated by people who are Asian. Well, one of the reasons why is because for a long time they were limited in what professions they could practice. And most of the professions that they could start a business in were service industry things like laundry and opening a restaurant to serve people and things like that. So there is a long tradition of Asian Americans being involved in those professions because they were the only professions that they could open their own business in. But in this case in 1886, strikes down these restrictions, essentially saying that it is unconstitutional to deny anyone the opportunity to open a business or compete for opportunities. And then, of course, the most well-known example of discrimination against Asian Americans is after the Japanese attacked the United States at Pearl Harbor in 1941. FDR issues Executive Order 9066, which forces 130,000 Japanese Americans into internment camps, which you can see the picture of here. These are essentially prison camps. They use census data to identify Asian Americans in our country, Japanese Americans, and essentially round them up and take them from their homes. They lose their homes, their possessions, everything, and are put into these prison camps where they are forced to work and live for the duration of the war. We weren't executing them, but it wasn't very different than what was being done to the Jews in Europe that we were fighting against. And so in 1988, Congress passed the Civil Liberties Act, and Japanese Americans become the first and only group to get reparations from the American government for the way they were treated during this time period. Native Americans. Now, one could make a very strong argument that Native Americans are the most marginalized and discriminated against individuals in the United States. We have come very close to damn near extermination of Native Americans in our country that has been endorsed by the federal government. The Constitution remains unclear on the rights of Native Americans because we have essentially we've made a system where they exist apart from the United States society. So we have, throughout our history, we have made treaties with Native American tribes. We have forced them onto reservations, but then we've gone back on, the deals that we made with Native Americans. And we're still seeing the effects of that today. Some of you may remember the conflict in Standing Rock over the oil pipeline, where essentially an oil company decided they were going to build an oil pipeline to bring oil from these tar sand fields in Canada down to the United States to be refined into gasoline and other products. Their original plan the pipeline would have run underneath American cities, and the cities didn't want to approve it, so they redesign it to run the pipeline under a reservation. And of course, the Native Americans do not want this to happen. And so they protest, they blockade the roads, they prevent the companies from working on the pipeline, and it leads to a standoff with federal agencies, federal law enforcement, where people are tear gassed, shot with these less than lethal bullets, but they can kill people and they can severely harm people. And eventually they build this pipeline under this lake that is the water source for the reservations. I believe it's either North Dakota. I believe it's North Dakota. And the pipe burst and contaminates all their water, which is what they were protesting against, was the fact that this could contaminate their water, and they were right. It does. And so on reservation land, Native Americans are supposed to be sovereign. They are essentially their own governmental entity. They have sovereignty on that land, get to decide what's what, make laws, make rules. But we consistently do not honor those agreements and come into conflict with Native American tribes all the time. And usually it's the government that imposes their will on Native American tribes. Throughout our entire history, we have forcibly removed Native Americans from the land that they have historically occupied, moved them onto reservations. Under President Andrew Jackson, we had the Trail of Tears, where many tribes east of the Mississippi are rounded up and forced to march to Oklahoma to be placed on reservations. Many of them die from sickness, hunger, everything. And it comes very close to exterminating several tribes. And so this kind of starts a process of the United States trying to strip Native Americans of their identity. In the 1960s, Native Americans protest and fight for greater control of the land, the reservation land that they have been forced onto to govern that land. The Indian Self-Determination and Education Assistance Act is passed to give them more control of their land. And this is in response to, through the late 1800s and early 1900s, there is an effort by the United States government to essentially eradicate Native American identity. This is done in a lot of different ways. Native Americans essentially are forced to speak English. Many of them are forced into religious schools to essentially take away their native religions and identity and teach them and assimilate them into white identity, Christianity, and things like that. Um, for a very long period of time in the early 20th century, Native American children are taken away from their tribes and adopted to white families. There's some documentation of white families buying Native American children for as little as $10. And they're sent to live in white society, and they're punished if they speak their language, if they practice their Native American beliefs. And so, for a very long period of time, the United States is actively engaged in trying to erase Native Americans from American society. Um, Today, that Indian Self-Determination and Education Assistance Act has given them more control over their education systems, how they make money. In 1987, reservations are granted the right to open casinos, even if the states that they are in do not allow gambling, because reservations are supposed to be their own sovereign land where they can do whatever they want. We are seeing more and more attention paid today to Native American issues, but that is a relatively new development. For most of our history, we have tried to erase Native Americans from American history and American society. Disabled Americans. In 1973, we passed the Rehabilitation Act, which essentially prohibits discrimination on the basis of disability. So, for getting jobs, going to college, all that kind of stuff, you can no longer discriminate against someone for a disability. The Disability Rights Education and Defense Fund is created. It's similar to, say, like the NAACP, but a group that advocates for the rights of disabled Americans. And then, of course, the big legislation having to do with disabled Americans is the Americans with Disabilities Act, which is passed in 1990. And this creates a lot of, equalizing type things for people living with disabilities. Like now we have to have wheelchair ramps on buildings, we have to have elevators on multi-level buildings, braille like on elevators. You'll see that now. And then, of course, like even the accommodations you get when you come to college to help with all different kinds of things that people might be dealing with. Grants equal access to employment, housing, healthcare, education, all that kind of stuff. The ADA really had pretty broad support. It's not something people advocated against. The state's main complaint over the ADA was that the federal government wasn't going to allocate any money to make these changes, that essentially they had to pay for them out of their own state budgets. And then LGBT civil rights, LGBTQ plus civil rights. The terminology is evolving and changing throughout time, but in the 1970s is where we see the beginnings of the civil rights movement for LGBTQ Americans. Now, it's not to say that LGBT people didn't exist before this. That's not the case. It's just that this chain of events really starts in the 1970s that causes an organization of LGBTQ people. So in the 1970s, we see the formation of several gay and lesbian rights groups. Lambda Legal, National Center for Lesbian Rights, Gay and Lesbian Advocates and Defenders. And this really starts as the result of an event known as the Stonewall Riots. And that's what the picture is here in the background. The Stonewall Riots happened in New York City. And prior to any of the protections we have today, we have the anti-sodomy laws, which essentially criminalized homosexual behavior. And so police could raid gay bars, police could arrest people and humiliate them, for engaging in homosexual activity. And so in 1969, at a bar called the Stonewall Inn. The police were notorious for coming to gay bars and just messing with people, coming in, raiding, arresting people. And on this particular night, it happens in 1969, I believe it is. The riots last from June 28th to July 3rd. And the patrons at this bar just decide that they have had enough, and so they start fighting back. Um, and they risk a lot in doing this because at this period of time there were no protections for gays and lesbians. So if you were outed, um, you could lose your home. If you were renting, you could be kicked out of your home. Your employer could fire you. You could go to jail. You could essentially lose everything. And so they start dragging people out and arresting them. And this is all being captured on camera by the news and everything. So all these people are being outed live on television and in the newspaper. And so they decide that they've had enough and they start fighting back. And they have a week-long standoff with the police where they're throwing bottles and bricks and, running and charging them and retreating. And they go back and forth for a week. And this is the event that really kind of kicks off the struggle, the fight for LGBTQ civil rights. Um, so this is where we see the formation of a lot of the organizations that start advocating for gay and lesbian rights at this time. Unfortunately, by the end of the 1970s, we have the HIV/AIDS crisis, which really kind of puts the damper on the progress of these groups because then they have to shift into this mode of survival because of HIV and AIDS. During the 1980s, which is where the bulk of the HIV/AIDS crisis happens, people won't even acknowledge it. President Reagan would not even say the words HIV or AIDS. He wouldn't acknowledge that it was even happening. And because it was happening to gay men, most of the country didn't care because they believed that it was, quote unquote, a punishment from God and they deserved what was happening to them. And for the people living with HIV and AIDS, their families completely cut them off. They won't, take care of them. Many people die alone because their families essentially shun them. But unfortunately, their partners have no rights. So when it comes to making medical decisions, property ownership decisions, all that kind of stuff, their partners, even though they may have been together for decades, have no power in these situations to make decisions and are essentially shut out by the person's family or by the law. It's not until President Bush Sr. becomes president that HIV and AIDS is acknowledged by the government as even existing. And it's not until President Clinton becomes president that the government starts to allocate funding in a big way to research for HIV and AIDS. And so HIV and AIDS for a while kind of puts a damper on the LGBTQ struggle for civil rights, but in many ways by the 90s it strengthens it because there's a lot of different issues that LGBTQ people are fighting for. Some other issues such as Don't Ask, Don't Tell come up in the 1990s. If you're not familiar with Don't Ask, Don't Tell, essentially it was the policy for LGBTQ people wanting to serve in the military. It was illegal if you were gay to serve in the military. If you were found to be gay, you could be dishonorably discharged, which is almost like having a felony conviction on your record. It makes it impossible to get certain jobs and loans and all kinds of stuff. And so during President Clinton's time as president, he wants to do something about this. He didn't believe in LGBTQ people being excluded, but he also knew that he didn't have the support of Congress to do anything significant about it. So he compromises with the Don't Ask, Don't Tell policy. So he himself is kind of in a precarious position because he doesn't have the support of Congress. Congress and many other entities want to ban LGBTQ people from serving. And so they come up with a compromise: don't ask, don't tell, where you don't ask or you don't tell, and your military administration is not allowed to ask. But if you were caught or someone saw you at, say, a gay bar, or saw you with a same sex partner, you could be dishonorably discharged. And this would not be overturned until 2010. The policy of don't ask, don't tell was ruled unconstitutional. In 2009, we get hate crimes protections applied to uh, crimes committed against people because of their sexual orientation or transgender identity. In 2013, the Senate votes to include sexual orientation and gender identity in protections for employment. Today, sexual orientation is protected. Gender identity is still kind of being debated in the court system. We have seen some progress, but there's not a definitive addition of gender identity to these protections just yet. And then, of course, in 2015, Obergefell versus Hodges is the case that legalizes gay and lesbian marriage in all 50 states. And then we talked about some of the other issues of privacy in the previous chapter.